Good afternoon, everyone. My name is Nancy Lopez. I'm a board member with DC Refers. DC Refers is a network of lawyers and mediators who provide high-quality legal and mediation services to people of modest means at below market rates. So our online panel will connect with people who earn between 200 and 400% of the federal poverty guidelines, and then provide services to them at between $75 and $150 an hour. Part of our mission is to provide community for those lawyers and mediators that are serving the modest means community. And so today we're really excited that our DC Refers Reconnect features Courtney Weiner, a consumer lawyer who's going to help us navigate some of the changes to student loan programs. I hope you will check out the DC Refers website. I hope if you have clients who are in that income range or higher, you will direct them to DC Refers. And I am pleased that we're co-sponsoring today's program with SEDEC DC. And so I'm going to hand it over to Ariel Levinson-Waldman from SEDEC so he can tell you a little bit about what they do, and then he will introduce Courtney and we'll get underway. Thanks for being here.
Thanks, Nancy, and thanks to you, and thanks to DC Refers, which plays such an important role in connecting people to help, who otherwise wouldn't have a place in the marketplace necessarily to find help. Hi, everybody. Ariel Levinson-Waldman with SEDEC DC. At SEDEC DC, our mission is to serve DC residents with lower incomes up to and including 400% of the poverty line, facing debt-related problems. And we come at that work through a racial justice lens. Like so many of the folks on this call, it's good to see so many of you. Because of what we see in the DC community with massive wealth gaps that from decades and centuries of structural racism, where wealth tracks race, and we have a credit and debt collection industry that through purposeful practices, both through corporate activity and government fines and fees policies, we see massively disparate impact on our neighbors of color. Since our founding, we have been blessed to have as a board member, the vice chair of our board, Courtney Weiner, who I've gotten to know not only in her hat as a board member, as a friend, as someone I admire and like a great deal, and just appreciate being in a foxhole with at any opportunity. But also Courtney runs her own terrific practice, the law offices of Courtney Weiner, with a focus on consumer finance, with a focus on consumer law, and excitingly, with a sub-focus on student loan debt. So I am delighted and honored to introduce Courtney, and I will turn it over to you, Courtney.
Thank you, Ariel, and thank you, Nancy. I'm thrilled that both DC Refers and SEDEC are hosting this event, and looking forward to sharing some of the latest information on student loans. One disclaimer that you've probably heard many times: this is general information, not legal advice. And if you need information on a specific situation, I encourage you to contact an attorney. Okay, so what is the situation with student loans? We've been hearing a lot about it. We've been hearing a lot about it because 1 in 7 Americans have student debt. Those between the ages of 35 and 49 owe the most money. And most of the debt out there, about 92%, is federal. The federal student loan portfolio is $1.6 trillion. Student loans are a little bit different from other debt. When you apply for a mortgage, for example, you submit all sorts of information. The lender makes an assessment of your ability to repay based on all of that information, which reflects your current ability. Obviously, things can change, but there is some assessment that goes into that. That doesn't happen with student loans, because most students are going to college relatively broke, and the determination on eligibility is, and more importantly, on ability to repay, is based on the expected value of the degree that student is going to be earning. Unfortunately, a lot of times those degrees don't have the expected value. So what that means is that there's a huge economic weight that, as Ariel was talking about, often disproportionately falls on people of color, but is really just overwhelming in its scope and prevents people from, for example, buying homes and making other major financial decisions. So that puts student loans at the center of the conversation these days. What types of student loans are there? There are federal student loans, and that's, as I said, most of it. And there's a bunch of different kinds of federal student loans. There are FFEL loans. Those are an older type of loan that stopped in, I believe, 2010, but a lot of people still have them. Those are loans that were made by banks, private lenders, but they're guaranteed by the federal government. And most of those, unless they've defaulted and gone over to the Department of Education, are still held by those private lenders. Or there's direct loans. Those are loans that are made directly by the Department of Education. And that's what most of the loans, well, almost all of the loans these days are. There's a few different kinds of direct loans. There's Stafford. They can be subsidized or unsubsidized. That's most of them. There's PLUS loans, which are loans that are made on top of the Stafford loans. Those can go to parents, or they can be for graduate school. Or there's consolidation loans, which a lot of people do as they are moving from their in-school deferment to repayment. It's also an option for getting out of default. FFEL loans can be consolidated into direct loans, even if you already have an FFEL consolidation loan. Another couple of types that are a little bit less common for federal student loans are HEAL loans. Those are actually made through the Department of Health and Human Services rather than the Department of Education. Those are for medical education. And then there's Perkins loans. Those are loans, they tend to be smaller, and they're made by the school rather than by the federal government directly. Those are also guaranteed by the federal government. There are also state and private student loans. One general piece of advice is do not consolidate federal loans into private. You will lose all sorts of protections, and there's a lot fewer options if things go sideways with a private loan. So do not consolidate, even if the interest rates look a lot better. The federal government has lots of different options for repayment. They're in two major categories. One is balance-based. That's based on the amount of the loan. And so, for people with lower balances, this is probably the way to go. It's also the default that you're likely to be put in when you start paying back your loans. You can pay over a 10-year period. You can pay based on a standard plan, which that's like a mortgage. Each payment is the same. Or you can pay on a graduated basis where your payment will start off low and then work up to being a lot higher. That is sometimes a good option if you think you're going to start off with a low-paying job, but pretty steadily work up to something where you're making a lot more money. There's also an extended plan that's usually about 25 years. That depends on the type of loan, but that's also has a standard and graduated option, and that usually just requires asking the loan servicer to make that change. For the extended plans, you have to have a balance of at least $30,000. Income-driven repayment plans are based not on balance, but as the name suggests, on the borrower's income. So that it's based on discretionary income. That's not the total amount you make. That is your adjusted gross income from your tax return minus, depending on the plan, 100 to 150% of the poverty index. There are several different kinds of plans, and the percentage of your income that you pay varies based on plan. It's 10 to 20%. The repay plan is 10%, and income contingent repayment is 20%. Income-based repayment is 15%. It depends on what kind of loan you have and when you got it. For example, the income contingent repayment is the only plan that's available for Parent Plus loans. Income-based repayment is the only plan that's available for FFEL loans, which is one of many reasons to consolidate an FFEL loan into a direct, because it makes you eligible for the 10% repay plan. So anyone with student loans, federal student loans, and anyone who's been following this issue in the news knows that since March of 2020, when COVID started, federal student loans have been in a payment pause, an administrative forbearance. Under that plan, no interest has been accruing on loans. One important thing is that the months during the payment pause will count towards public service loan forgiveness, which I'll talk a little bit more about in a minute, or forgiveness under income-driven repayment. Under the income-driven repayment, which I was talking about in the last slide, after 20 or 25 years of payments, depending on whether they're undergraduate or graduate loans, the balance of the loan is forgiven. So the payment pause has been great for people who are working towards that. They haven't had to pay, there's been no interest accruing, and all of that counts. That payment pause is coming to an end when the ball drops on December 31st. When that happens, the payment plan that you were using in February 2020 will go back into effect. So if you want or need a lower payment plan on income-driven repayment, you should get an income-driven repayment IDR for short application in as soon as possible, so that it will be in effect as of January 1st. The change that's been making the biggest news is the $10,000 loan forgiveness that President Biden announced. That is based on your income in 20 or 21 on your 1040, your adjusted gross income. It has to be, for you to get the $10,000, $125,000 or less for a single borrower, or $250,000 if you're married or head of household. The amount is increased to $20,000 if the borrower had a Pell Grant, and that's used as a proxy for an even lower income. Pell Grants are a need-based grant available to those going off to college. It is a short application. I don't think it's available yet, but it should be any day now. This only applies to loans held by the Department of Education, and that's really significant. Now, last week, if I'd been talking to you last week, I would have told you to consolidate as soon as possible if you have an FFEL, so you'd be eligible for this. Well, there's a lot of controversy over this forgiveness. There are a number of lawsuits that have already been filed or are brewing. One of those that was filed was alleging that there is some harm to loan servicers or banks that held FFEL loans because people would consolidate away right away. So to try to get ahead of that, the administration announced on September 29th that any loans not consolidated as of that day would not be eligible for the forgiveness. So if you started a consolidation application before the 29th, then probably still eligible. If you did it after, then you're probably not, but you should probably still consolidate because there's lots of other benefits to that I'll talk about in a minute. One other interesting aspect of this is that for those who have Parent Plus loans, so parents who took out loans to pay for their kids' education, the question of whether they are eligible for $10,000 or $20,000 off of those loans is based on whether the parent, when they went to college, had a Pell Grant, not whether their child had a Pell Grant. If you made payments during the COVID forbearance that you didn't have to make, so really any payments on a loan that was paused, and that amount would be part of this forgiveness, you can ask for a refund of your payments. Couple of other notes. This is still a bit of a question mark. It's all been announced definitively, but who knows what sort of litigation could derail this. There are also scammers who are waiting in the wings to try to get their hands on forgiveness money or refund money or whatever it is that scammers do. So be really cautious about who you're giving your information to, as always. One of the other major changes that I think is going to be of particular interest for this group is the public service PSLF waiver. So there was a story a few years back about how only a small percentage of PSLF applications were approved. So there's been some changes, at least on a temporary basis, to try to address that. The general formula for PSLF is that if you make 120 eligible payments while you're working for a qualifying employer, the balance of your loan will be forgiven. It doesn't have to be 120 consecutive payments, but it has to be 120 total payments. An eligible employer or a qualifying employer is a 501c3 or a government entity. Unfortunately, contractors for the government or for a 501c3, if your actual employer is not qualifying, does not count. It has to be full-time employment. And you have to make on-time payments for the full balance or the full monthly payment that's owed. So the waiver that was announced a number of months ago addresses some confusion about what eligible payment plans were. Technically, and as will be the case starting next month, the only eligible plans to get your loan forgiven are the 10-year standard plan or any of the plans under income-driven repayment. Really what that boils down to is income-driven repayment, because if you use this 10-year standard plan, your loan will be forgiven after your loan will be paid off after 120 months, just based on your regular payment plan. So if you're going for forgiveness, that doesn't really make sense. So if this is your goal, you should be in an IDR plan. This whole program started in October of 2007. So we're looking at payments made from that date going forward. Now, what the waiver does is that it makes any payment, regardless of payment plan, while you were working for a qualified employer after October 2007 count towards those 120 payments. It also will include forbearances of more than 12 months consecutively or 36 months total. And it will include deferment periods other than in-school deferment that were before 2013. This also only applies to loans held by the Department of Education, but if you consolidate a Perkins loan or an FFEL loan before the deadline, then the Department of Education is saying that it will still count. To do this, you need to, and your loan doesn't need to be ready for forgiveness yet, but this is just going to make sure that all of those previous payments that would not otherwise have counted, it will tee them up so that when you go for forgiveness in 5 years or 2 years, whatever, that you have that record already made. You must submit your waiver form, which you can get from studentaid.gov. It must be signed by your employer. You must submit it by the end of the day, by 11:59 on the 31st. Otherwise, goes away and you go back to the normal rules. One of the other big programs that's not getting quite as much press, but I think is going to have a major impact, is a recount of income-driven repayment payments made over the last period of time. And it's sort of similar to the PSLF waiver, although this is automatic. It is meant to address overuse of forbearance by servicers and other confusion about payment plans. Forbearances are when a servicer lets you take a pause on payment for a certain period of time. The problem is that interest is still accruing and gets capitalized into the balance of the loan, which then means you have interest accruing on your interest and can balloon the balance to really crazy amounts. I have people call me all the time saying, I took out loans for $35,000 and I've been paying for 10 years. Why do I owe $80,000 now? Well, if there are forbearances and if there are a lot of them, that's what can happen. So similar to the PSLF waiver, what this will do is make any payment, regardless of plan, count towards that 20 or 25-year forgiveness period. It will also count forbearances of more than 12 months consecutively or more than 36 months cumulatively. It will also count any deferment before 2013 other than in-school deferment. It will not count default time, in-school deferments, or bankruptcy forbearances. And again, this only applies to loans held by the Department of Education. So consolidate your FFELs. You must consolidate by the end of 2022 in order to be eligible for this. For those borrowers who were in default at the start of the pandemic, the start of the COVID forbearance, there is hope. In general, if you go into default on a student loan, there's some options. There's rehabilitations, there's consolidations if you're eligible for those. But the federal government wanted to make things easier for everyone, give everyone a fresh start, which is what they called the program. This does not apply to loans where there was a judgment, but if the loan was in default at the start of the payment pause, then when payments start up again on January 1st, the loan will be back in good standing. This will allow access to income-driven repayment plans that wouldn't otherwise be accessible. It suspends collection efforts like garnishment for all of 2023. And there's a lot of credit reporting benefits, both with major bureaus and government systems for government loans. For those who are perhaps looking to go back to graduate school or who took a pause on their education, this also restores eligibility for more aid. And that part went into effect already. Some of this will happen when the payment pause ends in January. Some of this is already in effect. To get the full benefits of this, you will have a 1-year period starting on January 1st to make payment arrangements. That is most likely to get into an income-driven repayment plan. And the loan will be transferred to a new servicer, so you'll have a fresh start with a new servicer. This includes both loans held by the Department of Education and FFELs. So, as I mentioned, some of the features like the renewed eligibility and the updated reporting, credit reporting in the federal database have already gone into effect. Others will follow. The credit reporting is really significant. The loan will be reported as current while the program is in effect. And if you go ahead and make that payment arrangement, then the defaulted trade line with the old servicer will be deleted altogether, and the loan will report as current with the new servicer. And as far as a mortgage lender is concerned, you only have this current loan. This can also reduce other living costs for borrowers, because your cost of credit and your cost of a mortgage, your cost of any sort of money coming in from a consumer finance source is tied to what your credit looks like. If you have this student loan default, then your cost of credit is going to be a lot higher. If it goes away, it's going to help. This program does not include Perkins loans held by schools. It does not include HEAL loans, the medical loans, and it doesn't include loans that are currently with the Department of Justice. Another major change that was announced at the same time as the forgiveness, but sort of flew under the radar a little bit, is a new IDR plan that's in the works. This has the potential to have a major impact. As I mentioned before, the lowest formula right now is 10% of discretionary income. This would be 5%. It would also change the discretionary income formula, at least for this plan, to be adjusted gross income minus 225% of the poverty index versus 100 to 150%. That means the 5% is going to be assessed against much lower income. This only applies to undergraduate loans. It's being worked out with rulemaking right now, so it's probably not going to go into effect until sometime in late 2023. I don't expect the litigation to target this the way it's targeting the forgiveness. If you have both undergraduate and graduate loans and use this plan, your percentage of income the adjusted gross income or discretionary income formula would be based on a weighted average. So if you're using Repay, your percentage would be between 5 and 10%. One of the recent changes, this actually just passed Congress like a week or two ago, is spousal deconsolidation. until 2006, there was an option for spouses to consolidate into a joint direct loan. The problem was there was no way to split them. So if the couple went on to divorce, and this was particularly problematic in cases of abuse, then one spouse could be stuck holding the bag. It finally got through Congress to allow these to be split. And I believe if the president hasn't already signed it, he's expected to very shortly. One last thing I want to talk about briefly that may not apply to most of the people on this call, but there's a borrower defense to repayment where you can get your loans entirely discharged based on fraud or other misconduct by the school. This mostly applies to for-profit schools. There was a case that recently settled, or it's in the process of settling, that came about because the Department of Education, primarily during the previous administration, was not properly processing, or in many cases not processing at all, borrower defense to repayment applications. For a long time, they were just sitting on them. When the lawsuit was filed, there was some agreement for them to start processing, but what that looked like was basically just stamping denied on all of them. So this settlement addresses the issue in a more meaningful way. There's an agreed list of schools where there is full and automatic discharge. For other discharge applications for schools not on the list, there is an agreed schedule by which the Department of Education will make a decision on applications, and that's based on the submission date of the applications. For loans, for defense applications that were submitted and were denied between December 2019 and October 2020, those denials will be rescinded and the applications will be reviewed again. For borrowers who submitted this discharge application, they're in forbearance until there's a discharge or a decision. This applies to both FFEL and direct loans, and it covers borrowers who had discharge applications that were pending as of June 22nd, 2022. And there will be notification within 90 days of the settlement of what's going on with or of eligibility for the settlement, and the settlement will be fully effective within a year. I believe there's a hearing next month to finalize the settlement. So those are the most important changes that have come about in the last year, and that will be in effect over the coming year and a half. I am happy to answer questions.
Courtney, while people are kind of gathering their thoughts and thinking about what their questions are, I want to say thank you. That was a tremendous amount of information. It is dense, it is complicated, and you did a great job of walking through it kind of step by step. I'm going to encourage people to either put your question in the chat or just unmute and ask the question if you have it. I saw a little bit of a response in the chat to like, what you're saying resonates with me, and here's why, and thank you for explaining that. Sarah, do you have a question?
I do. I have a question. Thank you. So thank you, Courtney. This was so helpful. I was hoping that you could touch on the forms that have to be filled out for the public service loan forgiveness. We have gotten a lot of requests from people have worked at DCVLP over the years, and I want to make sure that we're doing what we can to support them as they kind of navigate the process. We've gotten mixed requests, some for just letters indicating people worked at DCVLP during certain dates, and other people have provided actual forms that we need to complete. We're happy to do either, but I just wanted to make sure that for the people who are only requesting letters, that that is actually sufficient, or if we need to make sure everyone is giving us that standard form to complete.
So there's a couple of ways to submit everything. One of them is by primarily going through the online form that the Department of Education has and providing employer verification. I believe the letters would be sufficient for that purpose. That said, if I were advising a client, I would say to play it safe and use the official form.
Thank you.
And one clarification, the waiver form is just the regular PSLF form. There's no separate form that's a waiver. It's just the same form that a year ago you would have submitted to get your employment credits counted. It's the same. They will just consider it differently until the end of the month.
Are there others who have questions?
There's a couple questions in the chat, it looks like. It says, when you say that the loans need to be held by the DOE, does that mean that federal loans that are managed by programs like American Education Services do not qualify?
If it's a federal loan and American Education Services is the servicer, it should qualify. If you're not sure whether you have an FFEL loan or a direct loan, I encourage you to go to studentaid.gov, which will give you a breakdown of exactly what kind of loans you have. And it's actually very, very common that people don't know what kind of loans they have.
Another question was, are we able to get a copy of the slide deck? And the answer to that is yes. Courtney has graciously, there will be a follow-up email to everyone who registered with a link to the recording in case you want to watch parts of it again or share it with others, and then the slide deck as well. And then another question in the chat is there any news regarding the payment assistance from the DC Bar Foundation for lawyers at DC orgs? I understand that it restarts in January, but will we receive any payments for the months where we worked at DC orgs during the payment pause?
That I don't know, and I suspect there are others on the call who may actually have more information on this than I do. That I'm looking specific. I focus specifically on the loan side of things.
Yeah, the DC Bar Foundation probably can help with that answer to that question. And then another question, can I get student loan forgiveness if my loans are paid off during COVID?
That depends on whether you were required to make payments or not. If they were direct loans and they were subject or FFEL, depending on when there was a payment. The payment pause did affect FFEL loans at some point during the pandemic, but I'm just thinking through this. I believe only if they were direct loans and you were making payments that you did not have to make because they were subject to the pause, that you would be able to get that refunded and get forgiveness. If they were FFELs, then it's too late to consolidate to get to make them eligible. I see one question asking about whether the 31st is an important deadline. Yes, very, very important deadline. If you want PSLF loan forgiveness, or if you want your payments to count towards PSLF loan forgiveness, and they would not otherwise count, you must get your application in by 11:59 on October 31st. It is a bold red letter, very important deadline. This will probably not happen again.
And there's one other question. Can you elaborate on the lawsuits regarding the last point you made? Is there a list of those schools? I think there
is a website. Well, the Department of Education, studentaid.gov, has a portion of its website that's devoted to that. There's also a website that's devoted to the settlement. It's Sweet versus Cardona, so it's easily Googleable, and there's a list that is available as part of that. I don't have it at my fingertips, but it's pretty easy to find.
By way of just supplementing the discussion on the DC Bar Foundation, just flagging, we put in the chat contact information at DCBF for LRAP guidance from DCBF. And Stephanie Shane is a good point of contact there.
That's really helpful, Ariel. Thank you. And her email you've put in the chat, so that's great. Any other last minute questions? Then I think I will just ask folks to join me in saying thank you to Courtney. This is a huge help for people. It's a really complicated area of law. There's a million acronyms, and it's really helpful to get this information and have it be presented in such a great, cohesive, coherent way. I want to say thank you to everybody for taking time out of your day to join us. Thank you to CEDIC for co-sponsoring the program with DC Refers. And I will put in the chat again the links to our upcoming programs, both of a DC Pro Bono Week 1 on the ethics of low bono practice, and our next DC Refers Reconnect with Kelly Neptune, the Executive Director of the DC Bar Pro Bono Center. Thanks everyone for joining us, and thanks again, Courtney, for the great information.
Thanks for having me.